Right, we are here with Mr. Nihal Ameresekere in the GAP offices to talk about his recent publications regarding privatization and fiscal mismanagement uh, in Sri Lanka over the past, say, 12 years. And we have a series of questions we wanted to ask you about your profession and your work and the books that you've recently published.
I though it's Sri Lanka experience that I'm coming out with, uh, I must disclose that I'm a member of the International Consortium on Governmental Financial Management. I'm a certified fraud examiner, as well as a very important organization which I'm passionately involved in, the International Association of Anti-Corruption Authorities, responsible for facilitating the promotion of the implementation of the United Nations Convention Against Corruption.
Mm-hmm.
So in that context, my publications are to the global market. That's why I have a US publisher, so that the whole issue of how these transactions and how this mismanagement takes place of the management of public resources held in trust by rulers, whether monarchies or dictators or democratically elected governments, who are accountable to the people, is a global issue. And today, corruption has become a pivotal issue to the extent that after the G20 meeting, the executive director of UNODC issued a specific statement asking the global community to develop active agenda to fight corruption.
Mm-hmm. Can you tell us a little bit about how you came to be a public interest activist after having worked both in government and in the private sector?
It goes a long way back to the 1990s, early 90s, where I was compelled due to circumstances where the country was having very low foreign exchange reserves. Uh, there was a demand on a state guarantee, which I was responsible for partially for negotiating on the construction of the Hilton Hotel. And I was compelled to institute legal action, which I succeeded in the civil action, with the Supreme Court upholding the interim injunctions that have been issued by the lower courts, and no payments were payable. But due to socio-political realities of the Japan-Sri Lanka relationship at that time, with Japan being the biggest aid giver, the Sri Lankan government wanted me to enter into a settlement, which was finalized by the Attorney General, and I entered into a settlement and we took the case after the Japanese wrote off in 1995 Japanese yen equivalent to $207 million at that time, which is a figure that could have risked my life. So that experience I went through in prosecuting that action propelled me, if I may use the word, into the arena of public interest activity and public interest, subsequently public interest litigation.
I see. And you're also, as you pointed out, a chartered accountant and certified fraud examiner. In financial crimes in the United States, accountants and auditors have played apparently a more and more central role. And last week, PricewaterhouseCoopers settled with U.S. investors in the Satyam scandal of 2009. Are there measures, do you think, that could be taken to strengthen the tools that auditors and accountants have at their disposal to combat fraud and corruption?
It's a very cogent question. In my opinion, the auditors are supposed to be the watchdogs. But as I once told the Presidential Commission of Inquiry into Economic Crime, that they end up being lapdogs of the those who manage the resources, because they are the paymasters. Now, I go even back to Arthur Anderson, no more on the earth. In my own experience in Sri Lanka, on one of the privatizations, Sri Lanka insurance privatization, two major firms in Sri Lanka, that is Ernst & Young, were removed as auditors by Supreme Court decision, and PricewaterhouseCoopers, who handled the transaction as consultants of the government, were held accountable. A disciplinary committee was started by these chartered accountants, who just didn't see a fruitful result, because the networking of the socio-political network at that certain level inhibits action being taken. You scratch my back, I scratch your back. Even on the Hilton case, Ford Road, Thornton KPMG Photo Thought Company, certified the accounts, notwithstanding me as a chartered accountant having rejected the accounts, objected to the accounts. But then ultimately, by a court decree, they was removed as auditors. But in our country, unfortunately, all three firms continue to practice without the Institute of Chartered Accountants, of which I am a member, not taking any action whatsoever against those firms.
This seems to be an international problem, increasingly with the major auditing firms.
Yes, it is a issue that should be addressed in this global fight or combat against corruption. Auditors should be, as much as you will hold a religious leader, more accountable than layman to uphold norms. In terms of financial or fiduciary responsibility on financial chicanery, it should be the auditors who should be held to higher levels of accountability and moral turpitude as opposed to ordinary lay people or business wheeler dealers. But if auditors connive, it is like a doctor or member of the medical profession conniving in a murder. That's how I look at it.
Like, it's a violation of professional ethics.
Obviously.
Yeah. The work that you've done as a public interest activist, the litigation that you've done, the research that you've done, and the books that are recently published have to do with these fraudulent privatizations and tax amnesty that allowed the impunity for economic crimes in Sri Lanka. Those things took place, let's say, 5 years ago or more. Do you think that there has been progress by the government of Sri Lanka in curtailing economic crimes since then?
To me, not only Sri Lanka was not alone, because all those I'm on a mission of documenting not stories but real case studies. Real case studies, some of which were upheld by the highest judiciary in the country, the Supreme Court. We cannot pinpoint to Sri Lanka alone. There were many international players. For instance, one book is on hedging and derivative deals, where Citibank, Standard Chartered Bank, and also Deutsche Bank are involved. Then there was a Hilton case, where the Japanese firms Mitsui and Company Limited, Taisei Corporation, a reputed architect from Japan, and Hilton International as management contractor, were also involved. Then in the case of insurance privatization, there's PricewaterhouseCoopers from Indonesia, international player involved, and a supposed company from Gibraltar investing $10 million, whose identity was never disclosed to court. Then even in the privatization of bunkering, there is one of the biggest corporates, John Keells, in Sri Lanka, who is, to my shock, a global compact company committed under the World Bank program to combat corruption. So, but even those international organizations don't hold these people responsible and accountable.
So there we are. We know from the research that you've done and some of the work we've done here at GAP that tax amnesties like the one you researched in Sri Lanka and privatization, sometimes very poorly regulated privatization, has been the agenda of the international financial institutions for a long time. That is the International Monetary Fund, the Asian Development Bank, the World Bank. At the same time, these same institutions talk frequently about transparency and accountability. Do you think that the two programs can coexist, or are they inherently in conflict?
I would actually, the question amuses me. I would go beyond this word of conflict. To me, it's actually a laughing matter. I have worked on World Bank assignments. I've worked with USAID assignments. I've interacted, and it's amazing even that the IMF, World Bank, ADB overviews the Sri Lankan economic process and issues statements time and again The resident representatives, there are visiting heads from the World Bank, and I have interacted. One book will be on corruption, where I interacted with the World Bank president, and I get very nice letters, comforting, encouraging me in my activity. But it's only talk, no action. And in one privatization, which is in the plantation book, I found to my horror that the very ADB consultant on the privatization program was involved with a Singaporean company who was one of the parties who jointly bought one of the plantations on which that consultant was ADB consultant was consulted. So that it goes beyond conflict of interest, and that was a very bad privatization. And the privatization program was curtailed after the first after I was president. The plantations, these international institutions, I think they have one section promoting liberalization of the economy, privatization. Another section following up and trying to have transparency and anti-corruption work. I myself have been called upon to honorary work on reporting on corruption and transparency, and I point out that it's a useless exercise. The important factor is that if you are trying to liberalize the economy or the management of the resources of the people, the resources belong to the people, the government is only a custodian, a trustee of this management process. Then you have to have transparency, you have to have accountability, and you have to develop the confidence of the people, the confidence of the constituency, if you want the people to accept the supposedly liberalized economy. What happens is these shady deals take place where the wealth of the people are pillaged and plundered through these processes, and thereafter people lose confidence in the process, and there is lack of social justice leading to poverty and leading to social rebellion. I would say even justifiable social rebellion.
Now, in the work that you've done to combat fraud in privatization and in fiscal mismanagement, you have had to rely very heavily on the administrative legal system in Sri Lanka. And so we've seen a number of these privatization transactions annulled as fraudulent. However, there have been no criminal prosecutions. Is there a way, well, first of all, is the administrative legal mechanism secure? Can you continue to use that mechanism as a way to combat corruption? And is there some way, or is there even a trend now to strengthen the criminal justice system?
My experience is that I myself, though not a lawyer, appeared before the Supreme Court and made successful submissions challenging privatization, challenging the budget bill itself, the appropriation bill, very successfully, and the tax amnesty. The judiciary upholds. That's only a civil action by a individual citizen acting for himself and on behalf of the people, because I developed the concept that as a citizen I am a one person who has an interest in the consolidated fund. As much as all citizens have an interest in the consolidated fund, it belongs to the people. So you have a right to litigate, which the courts have accepted. But thereafter, and some of those actions, before we go to the criminal action, not some, most of the actions, I am bold to say, the Attorney General of the country opposed me. The Attorney General of the country opposed me in the Supreme Court, but I won. Judiciary upheld the stand I took. But in public litigation, I don't expect the Attorney General, who comes in sometimes as a amicus, a friend of the court, he should be supporting, if I'm telling the truth, supporting me. If I'm telling a falsehood, opposing me. But pro forma, I was opposed. And subsequently, it is the Attorney General himself who is called upon to enforce the criminal laws. And none of these people have been arraigned before criminal courts. The bribery commission that was there my statements are recorded on both the insurance privatization and the bunkering privatization for 4 days in both cases. And I told that person recording my statement, nothing will come out of it. He said, no, sir, it is going to, this time the commission decided to prosecute. As I predicted, nothing came out of it. Both were shell. On the contrary, the personalities involved have been given further public appointments. Let alone prosecution. So the rule of law doesn't seem to be applying equally to socio-politically affluent when compared to the ordinary people who are arraigned before courts of law on petty thefts and crimes, sometimes committed out of sheer economic necessity because of the system we have created.
Along those lines, excuse me, the one of your case that you mentioned, the privatization of the bunkering facilities in the Port of Colombo, John Keel's Holdings was a major investor and a beneficiary, apparently, of a fraudulent privatization. And yet, John Keel's Holdings continues to be a respected corporate citizen, it seems, in Sri Lanka.
That is the media.
Uh-huh.
The media and the social, including the Chamber of Commerce, I dealt with in my book, even the Chamber of Commerce. So it doesn't seem to have any sense of squeamishness. You pillage and plunder large public resources and walk about and shudder about like a peacock. So if whatever government in power, I experienced this through many governments. Ultimately, governments come to power not only in Sri Lanka, in many countries, in the US also, with the influence and the money backing of several interest groups, who then hold politicians accountable, payback period, full stop. It won't, the law is not enforced against those people, as opposed to ordinary people. Now, I would like to bring one little concept, if you permit me, into this theme of my books. And launching the books at a very auspicious moment. This is now, next week, the 2600th year of the emancipation of Lord Buddha, enlightenment of Lord Buddha. Buddhism is not a religion, it's a philosophy. In my books, every book, I have given 10 precepts from what the Buddha preached. On the facing page, I record what the socio-political reality is. This is what the Buddha said, not what I said. As a Buddhist or a Buddhist nation, we should follow that. We are supposed to follow it. We faithfully recite that we will follow it. But what is reality is disclosed in my books. Now, it is in Buddhist doctrine, long before the civilization in the Western world, which is cited in a famous case, the Danube case by Justice Veeramantri in the International Court, that the Arhat Mahinda preached to a king, that actual king of Sri Lanka at that time. King, what you perceive, what you have around you is not yours. You hold this in trust for the people. So it is a historical concept in Sri Lanka that the public resources and wealth belong to the people, and whether it be a royalty, monarchy, dictator, supposedly the democratically elected government, they are trustees in managing the resources of the people in trust for the people. Therefore, if you are a trustee, you are accountable to the people. You have to be transparent, and you cannot mismanage these funds. And most importantly, as I have seen now in the US, they're proposing budget cuts, you can't appropriate the money onto yourself. But I see many countries, not across the globe, they are elected, those in power, appropriate money onto themselves. Now, as a member of the International Anti-Corruption Association, we are very concerned, and I am very active in that organization. I will be selected as a member of an experts group to do a work plan for the International Association of Anti-Corruption Authorities, which is supported by UNODC, It's the host for the ensuring the taking forward by state parties who have signed the been parties to the UN Convention on Corruption, of this public accountability, good governance, and including identifying as PEPs, politically exposed persons, politicians, their relations, and those who are very close allies of the president, of the politicians. Now, their assets are to be monitored. Now, we find dictators being overthrown by waves of public opinion, rulers being chased out of their country, and it's only after the event that suddenly you find in the media somebody had $30 billion, somebody had $40 billion. But while this happened, everybody said cheese. Nothing really happened. So there is a need. There's a need which was endorsed by UNODC after the G20 meeting for the countries that have signed the UN Convention on Corruption to make it come to life. There's no point signing a convention and not adhering to it, implementing it. Then you might get blackballed and withdraw from the convention. But if you are signed as a sovereign state to uphold the preamble of the convention or recitals of the convention, then you have to develop your domestic legislature to ensure that there is compliance and this global menace of corruption that leads to the poor of the world becoming further impoverished. And the World Bank and the IMF that you referred to, I'm amused, come back with what I call poverty reduction programs. And I'm sure those poverty reduction programs are on further borrowings. So the poor have to, the next generation has to pay. In my opinion, those programs are only replacing the resource of the people that have been pillaged by a few. So it's better to ensure that there is no corruption, there is no pillage and plunder of the resource of the poor or people, and not impoverish the people. This is the phenomenon that faces the world. And finally, the books are conveying a message that it is economic terrorism that's the underlying cause that leads to social unrest, social injustice, and finally rebellion, and perhaps people are pushed to armed struggles, which in commas referred to as armed terrorism, which is again fought back by those rulers using the people's own money. And then that leads to violation of alleged human rights, which is too late in the day. At the root of the cause is the menace of corruption, greed by those in political power.
Thank you very much.
Thank you, B.